In this lecture, we are going to discuss the analysis of first chapter. First, we are going to see offer. Offer means when one person signifies to another his willingness to do or not to do something with a view to obtain the assent of the other. Means without any intention to obtain assent, an offerer should not offer anything. It, it is not even an offer. If intention to obtain assent of acceptor is there, then only offer constitutes place. Now we are going to see acceptance. The person to whom the offer is made signifies his assent thereto. Then the said person accepted the offer. Offer and acceptance combined together form an agreement. Agreement. We are now going to see what is an agreement. Agreement means it must contain offer and acceptance. Then we can also tell agreement equal to offer plus acceptance. In agreement, there must be two parties. One is offerer, the another one is acceptor. Agreement must be absolute and unconditional. Absolute means in fair terms. That is, if an offerer is offering something to the offeree, he should mention the correct details and description should be correct. He should say the exact price and the color of the car and everything, whether the car is in condition or not, and everything. He should not hide anything, or he should not tell any vague terms, that is incomplete terms which creates a doubt in the mind of acceptor. It should not be like that. That is absolute terms. For example, offerer has to tell the exact price. He should not say, I will sell you this product for 10,000 or 12,000. He should not say or, he should say the exact amount. And the next one is unconditional. Offer should not be conditional. Understood? Offer should not be conditional means there should not be any condition which should be put to the offer to accept. For example, if the offerer is saying that if the imported material comes, then only I can sell the product to you, it is not an offer. It is not an agreement. It is not an agreement. It is not an offer also, because to be an agreement, it should be offer also first. Agreement must be absolute and unconditional. If offerer puts any condition, then it is not an agreement. Understood? What we have discussed? Agreement equal to offer plus acceptance, and there is three main conditions in agreement. Agreement equal to absolute. Agreement must contain two parties. It must be absolute, it must be unconditional. Then we are going to see free consent. Free consent means no, you may know we are discussing the essentials of valid contract. In that, the first essential element is agreement. Now we are going to see free consent. Free consent means consent must be given freely without any influence on the acceptor. A free consent takes place only when the below five elements are not there. The first one is coercion, the second one is undue influence, the third one is fraud, the fourth one is misrepresentation, the fifth one is mistake. If any of these five are there, then it is not a free consent, and if it is not a free consent, it is not it is not an offer. It is not an offer, and if it is not an offer, it is not a contract. First, to be a contract, first it should be an offer, and to be a contract, it must be agreement, and agreement equal to offer plus acceptance. Therefore, first we have to see only offer only. Coercion means if a person is threatening other to do an act which is not comfortable and which is not with consent of the acceptor. Acceptor is afraid and then put and then do that act which the offerer is saying, then it is coercion. Example, if the offerer is putting a sword on the neck of the acceptor and tell him to sign the documents, it is not valid because it is caused by coercion, and it is coercion means threatening to do something to acceptor if he does not sign the documents, or if he does not do the act which is told by the offerer. In this case, it is a voidable contract. It is a voidable contract because in coercion, the acceptor may accept the offer or reject the offer. In when he puts case on the court tells him like that because it is not obtained by free consent. And the second one is undue influence. Undue influence means one person is showing authority over others. Authority in this sense means one is a stronger position and another is weaker position. Example, a doctor may exercise undue influence on the patient by asking additional fees or extra fees from the acceptor. If it is the case, doctor is exercising undue influence on the patient because patient needs to be safe, right? And patient gives priority to his life. Therefore, he is ready to give the money demanded by the doctor. And the third one is fraud. Fraud is an intentional mistake. It is said like that, but it is not mistake. It is do with intention. Active concealment of facts with the intention to defraud others. For example, if the offerer is selling a car in which all the parts are damaged, but it is painted like a new car for the purpose of showing to acceptor that it is in perfect condition, it is fraud because he knows the fact that the car is not well, but he is concealing the fact and trying to sell that damaged or not in condition. That is not a fit car, it is damaged condition. Offerer is trying to sell to acceptor, it is fraud. And the fourth one is misrepresentation. It is an unintentional thing. Offerer is not intended to fraud the acceptor, but he tells to the acceptor what he believes it to be true, but it is not true. If the offerer tells, for example, we are discussing misrepresentation. If the offerer tells to the offeree that he will rent his shed, or he will allow him to stay in his shed for some period of time, but he is not aware of the fact that the shed is damaged because of the heavy winds and rains caused last night. Misrepresentation means the offerer is telling or offerer is communicating to the offeree, that is the acceptor, that what he believes it to be true, but it is not true. Next is mistake. Mistake means mistake means when both parties are when mistake means when both parties are in mistake. If the offerer is saying that I will sell this if the example for if the offerer is having two watches, one is blue watch and one is red watch. If offerer is intended to sell the blue watch, but he is intended to sell the blue watch, but the offerer is thinking that the offerer is selling him red watch, then there is no consensus, that is thinking about the same thing in the same sense at the same time. Therefore it is not a proper therefore it is not a proper offer. Essentials are proper contract, because it is not a proper contract. If it is offer, then only it become contract, right? If it is not an offer, how it become contract? The other essential things of the valid contract are, then the other essential things of valid are its certainty of meaning. Offer must be certainty. That is, if the offerer is selling oils, for example, if the offerer is selling oils, a buyer came and sell, give me the oil. It is not certain, because oils are of different types. It may be kerosene oil, petrol, or cooking oil. He has to mention the correctness. That is, he should mention the certain meaning. And if he wants oil, he has to tell how much quantity, that is, how much liters he is going to buy. If he is not telling that, how can it become certain, right? Possibility of performance. The next thing is possibility of performance. If offer is given with an intention, offer is should be given with an intention to perform the act. If it is possible, then only offer should take place. Because if someone said that I will complete the complete course of law, CA Foundation Law, in 10 days, clearly and with a detailed explanation, how is it possible? It will take at least 2 to 3 months to complete full course. But if the offerer is giving such false promise, it is impossibility of performance. Because if it is impossibility of performance, it is not a valid contract. It is not a valid contract. Then we are going to see possibility of performance also completed. Intention to create legal relationship. Before entering into the agreement, both the offerer and the offeree should have the intention to create legal relationship. If they are not intended to create legal relationship, it is not a valid contract. Lawful object. Offer should be agreement, valid contract. Contract, to be a contract, it must be legal. It should not be illegal. If there is no license to purchase guns, but he is purchasing guns, it is illegal. Offer should be, the lawful consideration should be there. Lawful consideration means consideration should be lawful. If he is selling the land which costs 1 lakh for 10,000, it is not a lawful consideration, is it? Then the other thing we are going to discuss is competent parties. Offer should be, the contract should be between competent parties. If they are not competent parties means he should be major, that is, he is not a minor. He should be of sound mind, that is, he should not be unsound mind. He should be he should be he should be tell the third thing. He should be think and tell. He should be he is not disqualified from law. If he is disqualified from law, how can he enter into a contract? he should not be disqualified from law. The persons who are disqualified from law is convict, that is those who are under punishment in jail. Deserter, that is who person who has escaped from jail and roaming here and there to escape from police. Third person is insolvent. If a person is insolvent, he cannot enter into contract because if he is not having anything with him, that is amount. If he is not having any amount with him, how can he enter into contract? And he should not be of unsound mind. He should be of sound mind. He should be able to understand the terms of the agreement. He should have the ability to take rational judgment. Therefore, the last thing is agreements expressly declared to be void. Agreement expressly declared to be void are agreement with minors are void ab initio. Agreements means void ab initio. Contract means it is enforceable at the beginning, but subsequently it is not enforceable because because law uses it to be unenforceable because it is not in the interest of society. Thank you.